All right, the best place to begin this conversation is the latest. That is the date that has been announced. 17th of next month is the election date. About 43 days left. What a way to begin this conversation, and right from the person who's going to court tomorrow to complain about this, and that is one of the presidential candidates, Dr. Ekuru Aukot, Third Way Alliance. Thank you for joining us.
Thanks, Ken, and my pleasure.
All right, let's speak about your decision to go to court. This has been informed by the law, strictly to say, because one, you have been locked out. I want you to take us back to the 2013 ruling and why you feel you have a point.
First of all, I think my decision to go to court tomorrow to challenge the bad decision by IEBC is based on the fact that IEBC clearly did not seem to understand the ruling of the judges in the Supreme Court 2017 decision. Number one, the judges have not really pronounced themselves fully or comprehensively as to what they mean by a fresh election. So you cannot go on by citing another case where the judges either agree with it or not. Remember, this is the only court in Kenya that can actually change its mind based on a previous decision. So IEBC cannot purport to interpret the 2017 Supreme Court decision on the basis of a 2013 Supreme Court decision. The 2013, I remember the amicus curiae, the Attorney General, tried to persuade the Supreme Court judges not to depart from its decision on 2013, which was basically to say uphold the election of the president-elect. The judges departed from that, and in fact, the judges said hold fresh elections. Reason being that these presidential elections were not held in conformity with the Constitution, the rule of law, and the regulations. So basically, there was no presidential election, and that's why they declared the result as being invalid, null, and void.
Are you demonizing the IEBC for misinterpreting or totally not interpreting the law in this regard?
Basically, IEBC and Chairman Chebukati have emerged to be so ignorant of the basic tenets of the law and failure to understand the Supreme Court decision. If they truly want to go by this Supreme Court decision in its entirety, then they may have to wait until when the Supreme Court pronounces itself fully on all the aspects of the decision. Otherwise, the basic interpretation you give to the idea of holding a fresh election means that you must go back and do it afresh because you did not hold it in accordance with the dictates of the Constitution and the rule of law. So IEBC cannot bring in another interpretation outside the order of the court. And the order of the court is very clear. Go and do it again because it did not comply with the law. And the Constitution found that, the judges found that Chebukati himself, who was the first respondent, and IEBC, the second respondent, did not follow the Constitution and the law in conducting this election. Therefore, when you are told to go and hold it afresh, then it means start from the beginning. Let everybody else who participated in the first botched election declare their interest for it. The other important point to point out is basically a level of ignorance on the part of Chebukati, that they think that the judges pronounce themselves on a runoff. A runoff basically means the petition in this particular case, Raila Amolo Odinga, who says that I should have been declared the winner, and of course against President Kenyatta. So this case was not about a determination of a runoff. You remember the 2013 presidential petition, the judges pronounced themselves on what does it mean to hold a fresh presidential election. To determine that question, you need to look at the nature of the petition itself. The nature of the petition itself ought to be, is it a runoff or is it that the election was never really held in accordance with the Constitution? The 2013 decision was based on the fact that let's tally the results. Did Raila Amolo Odinga win did the President Uhuru Kenyatta win? And the judges said, based on what evidence was presented before them, President Uhuru actually won. This particular one was about the fact that the election was never conducted in accordance of the law, and that's why they say it is null and void from the very beginning.
The reason why it's a fresh election. But I want to pick your mind briefly on something here. If you look at the ruling, the 2013 ruling, and boldly, I just want to a little allude to it. I'll not read strictly what they said, but if one of the candidates petitions the Supreme Court, then that is the only candidate who will go for the election together with the respondent. However, when there is another candidate or two more candidates who petition a presidential election, then both candidates will go for an election. In that case, I'm looking for your role as an interested party per se, or as a petitioner, a co-petitioner, so to say, in the Raila Odinga and Kalonzo Musyoka versus IEBC chairman and, of course, Uhuru Kenyatta. What was your role? Because that will broadly bring out if at all you should be participating or not. Were you an interested party or you are a co-petitioner in this?
I was an interested party, but who adduced evidence on how the election was botched. Remember, let me remind Kenyans that under Article 258 of the Kenya Constitution, you do not have to be a petitioner to move a court of law to say the Constitution has been contravened. Anybody, any person who believes that the Constitution has been contravened or is about to be contravened could have actually gone to the Supreme Court today and said that this 2017 election was not held in accordance with the Constitution, and therefore sought the same prayers that NASA or Raila Molo Odinga sought. That therefore means anybody who believes the Constitution was not followed in the organization of this Constitution could have actually overturned the result and therefore arrived at the same prayers. So it is possible that anybody could have done it. And Raila Amolo Odinga going to court must have gone to court on behalf of all other Kenyans who are concerned about this election. Number two, the 2013 presidential decision was actually was declared that any other candidate who may have participated in the election may participate. It's a discretionary right, which means therefore, if I, Ekuru Aukot today, or Abduba Dida, or Wainaina, or Kaluyu, or Jirongo, and all the other candidates elected to participate in the repeat election, that is our discretionary power. It's not up to IEBC, who's supposed to be the referee, to dictate who actually participates in the next election.
Just tell me this. Are you moving, with all these confusions, Daktari, are you moving to the Constitutional Court for a legal interpretation, or you're where are you moving tomorrow if you go to court? Are you seeking for the interpretation? Because we know that the Supreme Court is not bound. Let me say this is their decision. They're not bound by it. They can change their mind. So are you going for a legal interpretation first? Just briefly.
Okay. Ken, first of all, thanks for bringing a very important point, which is that the Supreme Court of Kenya is the only court that is not bound by any precedent. It can actually change its mind, just like it refused to be bound by the decision of the 2013 decision. So it is true. I will be going to the Supreme Court because the case is still alive. The judges have not still pronounced themselves fully until when they give their full judgment. So I'll be making an application to ask the court to clarify what they mean by a fresh presidential election, what they mean by a repeat of the election, based on the fact that IEBC was found culpable, and so was Chebukati, that they did not hold this election in accordance with the Constitution and the dictates of the law. So I'll be asking the court to basically just clarify that one simple issue. And I think Chebukati is likely to be embarrassed big time, because they are rushing so quick to make a decision, a determination, without getting the full comprehension of what the judges mean. In my view, what the judges mean in the instant sense, that repeat this election afresh, without necessarily going into the rationale or the definition, or what we lawyers call the ratio decidendi of the case, is that this case must be repeated afresh.
Dr. Ekuru Aukot, thank you very much. There's a lot of things that I'd like to pick your mind on, but I will not do that tonight. Thank you very much for helping us understand that. That's Dr. Ekuru Aukot speaking to us on Skype regarding his decision to go to the Supreme Court, first for the interpretation, and then probably second, he'll be moving to challenge the decision by the IEBC to lock him out together with the other candidates. Well,